right, everybody, we're going to get started with our next segment. We're going to talk about some discrimination, state and federal discrimination laws. And so, if you remember, Berchem Moses is sponsoring this event. And so, Paula Anthony is here from Berchem Moses, and she's going to talk to us about all the laws that went into effect in 2021. So let's get started.
Thanks, Diane. As Diane said, my name is Paula Anthony. I'm a partner with Berchem Moses in their Milford office. I am a member of the Labor and Employment Practice Group. We represent management, public sector, private sector, and nonprofits. I'm sure as you all have been really busy for the last 18 months, my department has been equally busy advising people like you as to what to do. I kind of feel like we're back at the beginning with the vaccines, but luckily that is not my topic for today. So I know Lori did a good job explaining some stuff to you guys in terms of what to expect going forward. So I'm going to focus today on the anti-discrimination laws that went into effect this past legislative session. I do welcome questions because we're kind of dealing with discrete legislative actions. I do welcome questions throughout because I think maybe it's more relevant if we're talking about a specific topic to ask the question then. So please don't hesitate. I might ask you to speak up, and I'm wearing my reading glasses, so I'm not going to see you very well, but we'll get through it. So let's get to it because there's a lot to cover. So what we're going to focus on today is, as I said, the anti-discrimination measures that went into effect both at the state and federal levels. And we're going to look at some trending topics, kind of things to keep an eye on in that realm as we go into 2022. So let's talk about the legislative session. In Connecticut, we had our legislative session primarily January through June. Special session went a couple weeks into June. They enacted a good deal of labor and employment-related legislation during their session, including several important measures aimed at combating discrimination in the workplace based on a variety of protected classes. So we're going to talk about those today. Most are now in effect as of October 1. There were a few that I'll mention that went into effect upon passage, and there are a couple of outliers that are going into effect in the future, and so I'll point those out as we go along. So I'm going to start with the Crown Act. Connecticut is one of 13 states that have enacted legislation specifically to protect hairstyles that are traditionally, historically associated with race. Basically, what the Crown Act does is it modifies the definition of race in our state anti-discrimination statutes to include ethnic traits that are historically associated with race, including hairstyles. And, as you could imagine, and I think as Lori mentioned, we have litigation over everything. So they were kind enough in this particular statute to give some examples of what type of protected hairstyles that we're talking about. And so, they specify, it's not an exhaustive list, but they specify things like braids, cornrows, locks, twists, bantu knots, afros, and afro puffs. It also protects other hairstyles, including wigs and head coverings. So while I think that when we're talking about the Crown Act, a lot of times we're focusing on hairstyles that are historically associated with Black or African Americans, we are also talking about, in terms of wigs and head coverings, that could also apply to other groups. Think of Orthodox Jewish communities and Muslim communities as well. So as I said, there is some examples in the legislation as to what now constitutes an expanded definition of race. And obviously, race is one of the protected classes under our non-discrimination statutes. And so it just provides a broader definition of what can be included. So, what are the practical effects of this? Think of your dress codes or your appearance codes that you might have in your workplace. You really should go back and look at those to see if they, single out certain hairstyles or, they're not considered or previously weren't considered quote unquote business-like. We need to make sure that we are accommodating everybody's preference in terms of how they want to wear their hairstyle, especially those hairstyles that are historically associated with race and part of the identification for individuals in order to be able to, be how they want to be in the workplace without imposing restrictions on that. That's not to say that if there aren't safety issues, somebody wants to wear braids or their hair long, if it's a safety issue that maybe have to be tied back, but absent that, I think we need to take a look at our dress codes and our appearance codes and make sure that we are not singling out or precluding any groups under those existing codes. So if you haven't done that already, that law took effect upon passage back in March. It was one of the earliest anti-discrimination measures enacted here in Connecticut for this legislative session. One of the other laws or the other areas that the legislature tackled this year is breastfeeding in the workplace. Now there's existing law, pregnancy discrimination law, under this previous statute. It allowed for or provided for lactation breaks, and it prohibited discrimination for employees exercising the option to express milk at work or who may have other pregnancy-related reasons. And so you couldn't discriminate against somebody under the pregnancy discrimination laws. What this new act does is it modifies the existing law to require that an employer provide a lactation room or an area that is free from intrusion from the public while an employee is expressing milk. Now that's not to say that you have to build a room somewhere that's only used, sign on the door that says lactation room, but you have to provide a space that's a private space that somebody during their workday, if they need to go in and express milk, it has a lock on the door, there's not a window, that there's privacy, and that it's free from intrusion by others for that period of time that it's being used for that purpose. That area also has to include, it would be near a refrigerator or an employee-provided portable cold storage, which I think is a fancy way of saying a cooler, but I could include other things. I know I have an attorney in my office who has a newborn or not yet a toddler, and she has this little portable unit that she has in her office that keeps it cold, and so I'm assuming it could include that as well. And also has to provide access to an electrical outlet, so that if somebody has a device like I was just explaining, that they could then store the milk and it would stay cold. All right, so one of the big things that really is going to impact employers as of October 1 is the salary range disclosure, because it also is going to require that you guys look at your job applications and look at the way that you conduct your hiring process. This is a big one because it changes that hiring process. Under this legislation, employers need to disclose a wage range for a vacant position to an applicant before or at the time that an offer of compensation is made, or at the applicant's request, whichever is earlier. For current employees, you also have to provide that information if there's a change in their position or at their request for any reason. And so, it does define what they mean by wage range. I think that we're probably going to have some case law that's going to further kind of tweak that definition. But under the legislation, wage range includes the wage that you anticipate relying on to set the wage for that vacant position. And that could be a pay scale that's in a collective bargaining agreement. It could be a previously determined wage rate as you were defining what this position was going to be. You arrived at a specific pay range for it. It could be an actual pay range that you're paying somebody in a comparable position currently, and this is just somebody else who's going to be going into the same or a similar position. It could be the amount you've budgeted for that position. Whatever the criteria is, the point is to have something up front that delineates what the wage range is going to be to deter deciding what the wage range is going to be depending on who the applicant is based on some inappropriate or improper motivations there. This is going to apply to employers with one or more employees, so basically everyone. Did you have a question? Okay.
We don't really, whoa. I talk loud.
That's okay.
We don't really have pay ranges in that every time we set a range, people get paid above that range and then that range isn't really usable anymore. Mm-hmm. So if we based it just on internal equity and then also said that it could differ depending on how many years of experience they had and what degrees they had, would that be acceptable, or do we really need to try and find a better way to calculate that?
I think the important thing here is that it be predetermined. Mm-hmm. And so whatever your criteria is for determining what the wage range or the salary range is going to be for that position. In other words, it's not something that you wait until you see your pool of applicants, or you select a particular applicant and you decide on the wage rate after that. The idea here is to have something that's predetermined in terms of what you're going to offer for that position, regardless of who's applying for it. Yes, there are factors. Obviously, it's a wage range, so you may want to take it. You take into consideration, things like experience, but it shouldn't vary. The range shouldn't vary depending on who the applicant is, other than those types of factors.
Sure.
That are job related. Mm-hmm. So it's more being proactive and saying we're going to decide this ahead of time and then make a decision within that range based on our applicant pool and the successful applicant, as opposed to kind of doing it after the fact. Well, we'll wait and see what we get, and then we'll decide.
I mean, you look at a resume and you can tell where they went to school and how many years they have and where they might have worked before. Those things could all be a factor.
Sure. But the idea here is that it be previously determined. I think the key here is that it be something that's predetermined, either because you're already paying somebody that rate in that position, or it's within that range, or it's what you have in your budget for that position, or it's something that you've predetermined based on appropriate business criteria, but it's something that is decided ahead of time. Because you're going to have to provide that information ahead of time, depending on when the person asks for it.
Sure.
Okay? Yes. Oh, that's too far for my reading glasses.
Sorry, and you might have already said this, but does the wage range need to be added to the offer letter?
It doesn't to the offer letter.
Right. So
Well,
I typically give their compensation package and their offer in writing.
Sure.
So I'm wondering, if they don't ask me for it prior, do I need to include that in the offer letter?
Absolutely. It has to be before or at the time of the offer of compensation, or at the applicant's request if earlier. Does that answer your question? Yes. Yes. Absolutely. My background is in the...
I just asked if you could add it right to the job posting.
I'm sorry. The question was, could you put it in the job posting itself? Yes, you can. Some employers have expressed a reluctance to do that, but yes, you can. My background before coming to Berchem Moses was in the public sector, where that's done as a matter of course. Absolutely. Yes, another question.
Our hiring managers, so if they give them the salary range right at the interview, that's acceptable, right?
Sure, as long as it's before or at the time you offer the compensation, or if they ask for it earlier. Maybe they're applying, you know what I mean, and they say, how much does this pay? Then you'd have to tell them then. And you can be proactive about it. You don't have to wait for the employee to ask. However, it has to be before or at the time you offer compensation at the latest for applicants. Okay?
Hot topic.
Yes, it is.
Sometimes we're finding in this market that we have a range, then we talk to a bunch of candidates and realize our range is too low. So we revisit the data and we raise it. How do we address that with people we've already disclosed it to?
That's a great question. How have you disclosed it to them verbally? Have they verbally?
Verbally, we do it during the initial screen. When we reach out to them, we tell them the range of the job and all that good stuff.
Well, that's a good question. I'm not sure I know the answer to that. Does anybody have a suggestion for her as to how to best address that?
I have a
I think-
suggestion.
Yeah,
How about
both these lights, yes.
How about you tell the truth? And
Well-
you say, hey, we realized we were low.
I was talking more about the mechanism. That's why I asked her how she did it. If you're having it during an initial screening, do you have contact information? If you have contact information, if you have an email address, then I agree with you.
That's the question. Do we call all 44
Right.
people that my recruiter spoke with, which can be a bit of a logistical nightmare.
Sure.
So I don't mind
Right.
saying we raised the range. That's fine.
Right.
It's more of a, we're a small, relatively small
I
shop, this kind of thing.
think, however, that perhaps the better way to do this is to be more proactive and to make sure that you're reading what the market is, and so you don't have to go back and say, oh, we offered something too low.
That's great.
Yeah, I
Except in
know.
this market, you are sometimes hearing ranges that are 20 grand higher than what we use salary survey data when we come up with a
Sure.
range. So we don't pull a card out of a box. We do work with our comp analyst, but the market is saying something crazy sometimes.
Yes, Lori has an idea.
Since you can only tell the truth as of the time you're saying it, you know, you would maybe only tell the people who are still in the running at the time you raise the range, okay, the range has changed. For you 4 people who are left, this is what it is. I wouldn't go back and tell people who have been eliminated.
Well, not if you have 44 people. I was thinking we were talking about a smaller number. I think I was thinking that we were further along in the process, as you suggested, where you have a handful of the viable candidates that you're really going to be considering for the position. Any more? Yes.
What I did, and I hope it's okay, it just was very helpful to me because I look at a lot of resumes in several states. So if I have an interest in someone, I do we use Indeed a lot. I do a quick email, what is your salary requirement? I get it. I don't ask what their salary history is. I ask what their salary expectation is. I don't ask for history, never ask for history.
Right.
They give it to me, and now I guess what I need to do is, that's outside of our salary range, which is boom, boom. Can I do that?
I think that, asking somebody what their salary requirements are was something that kind of predates this new legislation. I think now you need to be more proactive and have in mind what that position is going to pay, whether it be because you've budgeted for that, whether it's because somebody else is in that position already. And I think that you have to be more proactive in saying, this is what our salary range is for this, because you're going to have to disclose that information regardless of, again, that's person specific. You know what I mean? This legislation is really more position specific. Well, you're not locked in. I mean, that's one of the criteria that they use in terms of the definition on how you arrive at what the wage rate is. It doesn't have to be a budgeted amount. As I said, it could be the prevailing, a prior determination of what that's going to be. It could be the pay scale. It could be something that you're already paying somebody else in that position. So it's just an example. It doesn't mean you have to use a budgeted position. Maybe that doesn't work for you because you don't want to be locked into that budgeted amount. Not everybody is in that position. Well, I think the point here, though, is that you are disclosing what this position is going to pay for everybody, right?
Paula, what was that question that the gentleman just asked?
I'm sorry. He asked could you just pay above the budgeted amount? And I was saying that it doesn't have to be necessarily based on the budgeted amount. That was just one of the criteria in terms of determining how they define what the wage range is for purposes of the statute. Okay, so I'm going to move on to the next. It's actually related to this particular statute that was enacted, and that is that the legislation also changed what the wage discrimination standard is going to be. So previously, it was equal pay for equal work. This legislation now provides that it's equal pay for comparable work. Okay, it's broader, and you can use a different pay for comparable work only in certain circumstances. If it's pursuant to a seniority system, if you have a merit system, if it's based on quantity or quality of production, and other bona fide factors, and this gets back to what we were talking about before, education, training, credentials, geographic location, and experience. They have to be job-related, and they have to be consistent with business necessity. And so this is going to be significant, and as I said, going to lead, I'm sure, to litigation in terms of what's comparable. But we're just going to have to, I think, wait and see how the courts kind of define and tweak that standard. But it does change the standard for how pay equity is going to be measured going forward. That legislation went into effect October 1st. So just keep an eye out for that. In other words, this is based on the pay equity for gender. And as I said, you can differ from that, but it has to be a bona fide reason. And I would recommend that you document that if, in fact, you do pay somebody in a comparable position a different wage than somebody else, that you document the reasons why you did that, so that if, in fact, you are faced with litigation over that, that you have documented why you varied from that particular comparable rate. Another area that has been the focus lately is transitioning incarcerated individuals into the workforce. And so there have been, on a local level, a lot of municipalities, New Haven, Bridgeport, have enacted ordinances. We have legislation at the state level that deals with individuals who've had their criminal records erased. Existing law prohibits discrimination against an applicant. You cannot ask an applicant, you remember the ban the box statute, you can't ask an applicant about erased criminal records. And if somebody has their criminal conviction erased, that they can lawfully swear under oath that they've never been arrested. This new legislation modifies the Connecticut Fair Employment Practices Act to make it discriminatory to deny employment to an applicant because of erased criminal records, or to treat them differently based on their knowledge of erased record information. The statute also provides for automatic erasure of certain criminal records, criminal convictions after a period of time. This statute is one that did not go into effect this past October. It does not go into effect until January 2023, but still something to be aware of. There is existing law, as I said, that you can't ask about erased records, but this now makes it a discriminatory act, modifies the Connecticut Fair Employment Practices Act to include this as a protected class. As we face a graying workforce, there have been efforts at both the state and federal levels to address age discrimination in the workplace. Under the Connecticut Public Act 2169, you can no longer ask an applicant their age, their date of birth, their graduation dates, or dates of attendance at educational institutions. In other words, you can't ask them information that would disclose their age by even not asking their age. And so I think that if you haven't done it already, you need to take a look at your job applications and make sure that they don't have any of those questions that would be age-related. This went into effect October 1st, and it applies to employers with 3 or more employees. The only exception is if there is a bona fide occupational qualification based on age. So, for example, you can't hire minors who aren't able to work. You can't have somebody serving alcohol if they're not of a certain age. Police officers have a certain age a threshold. So if there's a bona fide occupational qualification at either the federal or state level, you are permitted to ask about age-related information on application. Otherwise, you are not. So if you haven't done it already, make sure that you take a look at those job applications and you make appropriate adjustments to them. Yes?
If we want to verify their education, we can ask where they went to school, just not when they went.
Correct. Correct. And I think even for those situations where you need to make age-related inquiries, maybe you're asking a question, are you over 21? You know, instead of asking your date of birth, you're just asking everybody the question, are you over the age of 21? If to use my example of a server, someone who would be serving alcohol.
We asked for a degree, like their paper degree, so we could verify the education if we needed to, because that's part of our background check.
Okay.
Not allowed to ask for a degree anymore because that will list when they went to school.
When do you ask that pre or post offer?
Post offer.
Post offer, you're okay. You can't ask it on the application. Okay? Any other questions on this? Okay. So also related to, could be related to age, is the worker recall by seniority. This legislation was enacted really in response to COVID and the mass layoffs that ensued earlier in 2020. And so what this public act does, it protects employees who were laid off due to COVID between certain dates, March 2020 and May 2022. It is limited in its application to those in the hospitality, food service, or building service industries, and it is limited to employers with 15 or more employees. So it does have limited application, but if any of you are involved in any of those industries, you should be aware of it. And what it requires is that notice be given to laid off workers and that they be recalled based on seniority to any jobs in which they are qualified or could be qualified with training. And so, you know, you need to call those employees back first. Now, if an employee takes a pass and says, you know, I'm not ready to come back to work, or I can't come back to work due to age or an underlying condition related to COVID, they can still get a second bite at the apple. If another job opens up that they would be qualified for, you would need to send them notice again. And this is going to remain in effect, that second bite, that recall, until the end of the public health emergency, which at the time this legislation was enacted, we were looking at September 30 of this year, which has come and gone, and emergency authorization has been extended to, I believe it's mid-February, and so we've extended that time period. It also prohibits retaliation against employees for exercising their rights under this legislation, and provides for a cause of action in the event of violation. That went into effect in July of 2021. So since we're talking about discrimination, I think all of you are familiar with the CHRO, which is our state agency that deals with discrimination complaints in the workplace, as well as housing and public accommodations. And so there was some legislation 2 years ago dealing with sexual harassment claims with the Time's Up Act as part of the Me Too movement that extended the time limitation within which an employee could file a sexual harassment complaint to 300 days, which is the same as the EEOC time period. With this new legislation now, it expands that time to file a CHRO complaint to 300 days for all actions under the discrimination statutes. And so it's consistent with the CHRO timeframes, as I said. However, just be aware that it obviously extends to almost a year, the time period within which you may expect a discrimination complaint from an employee. So just be aware of that. That went into effect on October 1st of 2021. And so we'll see what that holds, whether that's going to result in an increase in claims or not. I don't know. That remains to be seen, and we'll have to just follow the numbers when CHRO releases them. Under the budget implementer bill that was passed during the special session, there were several more employment measures that the legislature enacted. One of them having to do with workers' compensation and providing disinformation to employees. There was already a statute on the books, 31290A, which prohibited discrimination against employees who exercised their rights under the Workers' Compensation Act. This now makes it unlawful for employers to deliberately misinform employees or discourage or dissuade them from filing a workers' comp claim or putting in a claim for benefits under the Essential Workers COVID Assistance Fund. And so that is not insignificant. It extends, again, the discrimination laws with respect to individuals who have exercised their rights under the Workers' Compensation Act to not only prohibit discharge or other adverse action or retaliation against them, but to also prohibit simply the deliberate providing of misinformation. I want to make sure that we're clear on that. You guys aren't going to be held to, you're not lawyers, you're not advising them on what the law is, and an inadvertent misinformation is not prohibited. It would have to be deliberately misinforming them or otherwise dissuading them from filing a claim under workers' comp. I think that it came up in the context of COVID because, and I know that there were some questions earlier about whether or not an employee who gets sick or who's exposed in the workplace might file a workers' compensation claim. And so I think this was to dissuade individuals, employers from dissuading individuals who may have a claim. Doesn't mean their claim is going to be accepted, but just the act of impeding their ability, kind of like with the FMLA, you have your interference claims. I would liken this to that type of situation where by providing misinformation, you are dissuading them from exercising their rights. One of the other things, this also came out of the budget implementer, and employers are going to be required to report employee demographics. Now, this is going to be phased in over a period of time, but the idea here is that employers are going to be required with their quarterly unemployment reports to provide employee demographics including gender identity, age, race, ethnicity, veteran status, as well as hours and wage information and dates of employment with respect to their workforce. It's going to be phased in based on the number of employees from large to small, and this will go into effect between 2024 and 2028. Employers would be allowed to request a one-year waiver for undue hardship. They don't, of course, define what undue hardship means, so I'm sure that we'll have to see if they provide some more detail before this actually goes into effect. But a waiver can be requested for 1 year by submitting a request to the DOL with 30 days notice. So let's look at the federal quickly. There was not really a lot of action on the You have a question, yes?
The slide prior. So currently filling out the EEO form for us is optional.
Okay.
Is this going to make it mandatory?
I suspect that they're going to probably detail some regulations with respect to this particular legislation. I think that's probably why it's so far out. So I don't have any specific answer to your question, other than say, stay tuned. As is the case with some legislation, they pass it and then they kind of, figure out the details later, like they did with the Connecticut paid leave. So stay tuned for how that's gonna roll out. As I said, I think that's probably why they gave it as much lead time as they did. Good question. So as I was saying, on the federal front, there wasn't a lot of legislation. Most of the action dealt with COVID in one way or another between executive orders and the CARES Act and all sorts of things. But there are some important indications about where things are headed and what to keep an eye on. So I mentioned earlier efforts at both the state and federal levels to address an aging workforce. The House passed a Protecting Older Workers Against Discrimination Act back in March, I believe, of 2021. It revises the evidentiary standard for age discrimination cases to be only a motivating factor. It doesn't have to be the sole factor. It's a mixed motive test. I'm not going to get into the specifics of it other than to tell you that it broadens the evidentiary standard for employees who are bringing lawsuits based on age discrimination. And it also limits damages to declaratory or injunctive relief where the employer can show that it would have taken the same action absent age as a motivating factor. So this right now, the status is only past the House so far. There's been no action on it since June. As I said, I think that the federal government has been largely taken up with other measures at the time, but I would stay tuned and watch this. It's still kind of in the hopper there. Lori talked, I heard a part of the tail end of Lori's presentation. I know she talked about long haulers and COVID under the ADA. I mentioned it here. You didn't think you were going to get out of talking about COVID in like everything we talked about today. But it really has kind of pervaded everything we do. And so just keep in mind that the EEOC, as Lori, I think, had mentioned, recognizes long COVID as a disability under the ADA. And so I think that we may see some litigation coming out of that. Certainly we know where the EEOC stands on it. And this may be a situation, obviously, that requires reasonable accommodation. I'm not going to speak too much more about that, but just to make you aware that it's on your radar. Again, federal and state mandates, and I know other people have talked about them. Requirements vary, and it's kind of in a state of flux right now. And the only reason I mention it is because it obviously implicates discrimination cases with respect to religious and medical accommodation requests. I think we're going to see a lot of litigation for those who are denied requests and subsequently lose their jobs with respect to these vaccine mandates. So again, stay tuned for that. Somebody asked a great question earlier about disparate impact for, I think it was you, asked a question about disparate impact. And I think that that's a good point. And I think that for employers, when implementing these policies, who aren't subject to mandates, because then you don't have a lot of wiggle room, but I think that you need to at least consider that vaccine hesitancy might be more prevalent among certain groups, and it may have a disparate impact on the workforce. And I think you need to look at, read the room and who your workforce is. Again, aside from the mandates, you may have no choice. But I do think that we will see some disparate impact litigation come out of COVID. I'm going to talk quickly about what's happening up at the Supreme Court. In the prior term, some of the discrimination cases that the Supreme Court had come before them were more important for the cases that they denied certification on as opposed to those that they actually decided. And one of them had to do with a hostile work environment case, and this is the Collier case that you can see up on the screen. And basically, in denying certification, it had the effect of affirming prior holdings and basically reaffirmed the Supreme Court's earlier decision that a single use of a racial epithet may not be sufficiently severe or pervasive to create a hostile work environment. So, as I said, sometimes what they don't take up speaks louder than what they actually do decide, and I think that this is one of those cases. The Supreme Court opened its current term in October and has been deciding cases fast and furious. For one case that's particularly relevant to what we're talking about here, again, was a case in which they denied certification, and that had to do with an appeal by a Catholic hospital in California, it was seeking to avoid a lawsuit over its refusal to let its facilities be used to perform a hysterectomy on a transgender patient who sought the procedure as part of a gender transition. And the impact of denying certification let stand a lower court decision that allowed the patient's lawsuit to proceed. His lawsuit claimed that the hospital was intentionally discriminating against him because he is transgender. The allegation is that they had originally scheduled the surgery but canceled when they found out that the reason for the hysterectomy was to treat gender dysphoria. So that case is going to be allowed to go forward. There's an upcoming case that the Supreme Court's taking up. It's a CVS Pharmacy versus Doe, which is a disability discrimination case under the Rehabilitation Act and by extension the ACA. And the issue there is whether the plaintiffs, who are patients living with AIDS, HIV, can bring a disparate impact claim for disability discrimination. Their employer-sponsored health plan requires that they fulfill their prescriptions at CVS. They are CVS employees. And the claim is that by requiring that, they are forcing them to forego essential counseling and consultation from specialty pharmacies. So they haven't taken that up yet, but it's on their docket. There are a few other pending petitions before the court. Whether they'll take them up or not, take these cases up or not, remains to be seen, but they're going to impact things like affirmative action, religious and First Amendment cases, and a variety of discrimination claims. So in terms of trending topics, I'm not going to dwell on this. I know this big red thing's telling me that my time is up. But I think that, in looking at the data from the EEOC and the CHRO, cases have been on the decline over the past couple of years. But people haven't been in the workplace, they've been home. And so I'm not sure we can read too much into that. There is, however, in the cases that have been filed, there is a rise in disability and retaliation claims, and I think that we can expect those to continue with COVID. I think that you're going to see cases for failure to grant leave. You're going to look at cases for failure to accommodate. You're going to look at cases for failure to grant vaccine exemptions. And so I think that those things are coming. Whether they're going to result in any significant shift remains to be seen, but I do think that they're coming. Also not on the docket, but something to watch, there are, I guess it's having to do with remote work, and I guess that's kind of what we're talking about with the reasonable accommodation. I think that that's it. There's one more thing, just briefly. You might remember the case of Bostock versus Clayton County, Georgia. That was a Supreme Court case that I think it was penned by Justice Gorsuch, and I think it surprised a lot of people because in his decision he extended the definition of sexual discrimination to include sexual orientation and gender identity in that case. And so the outgrowth of Bostock, I think, has been that there's been changes in the area of LGBTQ rights. The EEOC has issued guidance fairly recently that provides some insight on how they're going to be interpreting the fallout from the Bostock case. And the guidance addresses things like gender stereotypes and dress codes, pronouns and use of names, access to bathroom and locker room facilities. And so I think that that's something that we need to take a look at. I know there was a recent case in Texas now where we're going to be dealing with how that case kind of is going to intersect with religious employers and religious organizations in terms of both asserting rights and how do we weigh those and how do we balance those. So the takeaway, and I thank you all for your time, is that if you haven't done it already, you need to review and update your handbooks, your employment applications, your policies to make sure that your company is complying with the law. I thank you all for your time and attention.